Three Amigos, SJL Restaurant Inc. versus DBA The Cheetah Club versus CBS News. The Chief Judge is recused from this case. Mr. Whitehorn, welcome.
May I have a brief rebuttal, 3 minutes?
Great.
May it please this honorable court and your honorable judges, I appear here today on behalf of the plaintiffs, appellants, Three Amigos. I believe the application is as simplistic as it could be, and the solution is as equally simplistic. We have a complaint that alleges certain factual components of a cause of action sounding in defamation.
Before you get started with that, what I noticed in the complaint was each one of the individuals, O'Neill, Callahan, and Stein, are recognized in the complaint as employees of someone else. They're not suing in their individual capacity. Is that true?
I didn't read it implying the same thing. I thought it was clear, both in the opposition during the motion practice.
O'Neill was at all times relevant to this action, president of Times Square and involved in day-to-day operations. Callahan, at all times employed by Times Square. Stein, manager and consultant.
Correct, it does.
They're all suing as employees and or managers of the place.
And in addition, the entities appearing, the Times Square one.
Right, but they don't sue individually in their own names, right?
I believe they did, Your Honors.
Okay, well, that's just something I noticed.
Okay, I appreciate that. What appears, again, what I was getting into the simplicity of it is that we have an arguably sufficiently pled cause of action for defamation. Then we have a pre-answer motion to dismiss that seeks to attack that presumption that we have to rely on, that the allegations of the plaintiff are considered to be true for purposes of determining the motion. And then we have the assistance of CPLR 3016A, which further identifies what sufficiently pleads a cause of action for libel. When applying that, we're supposed to look to, we as a court and as a state, are supposed to look to the elements of that cause of action, see if factually there's reference to this component of libel and defamation slander for being of and concerning. So did the complaint, in fact, allege of and concerning? Now, I think as a most simplistic perspective, if we have the appellate division hearing and ruling 3 majority and 2 dissenting, clearly could argue just in and of itself there's an ambiguity. I have some learned judges in New York.
So what's the standard? Is it whether a person could reasonably understand the allegations to be about the plaintiffs? Is that the standard?
Critical to the analysis. It is. It's not a judge could reasonably interpret, not a law-based fact finder that has access to hyper-technical analysis of what is or isn't run by. So we have the majority ruling what is the definition of run by when the standard Your Honor just referred to, which appears regularly in the case that we cited on the appellate division of our district, and of course we refer to federal as well, that states clearly and unequivocally it can be interpreted through intrinsic evidence. It can be interpreted through the perspective of the reader. Now,
well, let me ask you about that. Let's assume for a minute that the owner or the operator of Cheetahs is a guy by the name of Sam Zerka, and that he's in jail for a whole bunch of things. Correct. Now, if he's running it, why isn't that a matter of law? I mean, to say that these people who work for other corporations that work for Cheetah are somehow running it. I can see where a jury could say, well, they're serving drinks, so they're running it. Well, that's not true. Or somebody can say, they're hooking up the dancer with the private room, therefore they're running it. That's not true.
Apply what you just suggested to the limited scope of factual information that we're dealing with. We have a statement made on live broadcast on video by 2 people of the defendant. One says that it involves the Mary Calvi states developing story, blah, 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 that the club behind me is at the center of a global scheme to bring women into the United States.
Right, and I think it was the appellate division, might have been the lower court, said that the only picture there was Cheetahs.
Right.
None of your clients.
My reference to the bring women into the United States. The next article, the next statement made by Ms. Brown, again refers to the women. When you look at the statements of facts submitted by the plaintiffs in the case, who controls the women? They run, no, the individuals that are the plaintiffs in the case.
It's nowhere in there. It's nowhere in the report. No one knows who your clients are until you sue.
I want to follow up on that point, because it seems to me that Judge Piggott's hit on one of the difficulties I see in your argument is that the plaintiffs are not identifiable in the statement. So the only way that they can become identifiable is under the theory that was set out in the dissent. I think Judge Kaepernick talked about small group defamation. I'm assuming that's the essence of what you're arguing here, that this group is so small, but federal authorities say this club is run by the mafia, does not identify them in any fashion, except for by the size of the group that's involved. But you are a self-selected group since you brought the defamation action.
Again, your reference to self-selected group, your reference to this scope of facts this is a pre-answer motion to dismiss. There hasn't been a discovery.
Yeah, that's
in
true.
all the other cases.
No, that's true, but that still doesn't get you over the hurdle. You still have to be able to say that you've alleged a defamation here, and in the statement, and that's what I'm asking you about. Are they identified? If so, how?
We refer to the complaint, and then the court as well during the trial judge's determination of the motion. They can look to affidavits. You see the affidavit of Mr. Stein referring to factual control made by him throughout the entire time that he's been there, where he controls the booking of the girls. He controls the calendaring.
Is your argument about who controls, or is your argument about what the people who go to that club and know them and see them reasonably would believe when they heard that statement on the TV?
We're saying it's both. We're saying that the impact, so this analysis of and concerning, it's just one component of this libel. Our greater argument and then our specific argument, they both touch on the same thing, which covers both of what you just asked. So of the elemental requirement, we say that the sworn affidavits presented to the court during the trial court indicate unrefuted. They can't even be refuted. It has to be presumed as if it's a fact. They state factually, we are the people that are in control and are being affected by this.
So your argument is the patrons would understand that
from that perspective,
runs
yes.
Cheetah, that colloquialism, runs Cheetah,
correct,
means what these people do,
correct,
what your clients do.
And the colloquialism of the term, the use of the term mafia. Mafia has been known throughout the past 40, 50 years of our history as a wheel, and the spoke of every portion of that wheel is a component of that organized crime, that syndicate of crime. So where is it? Where is it with an article that's not just printed? You have a live video. It's not taken in all the other clubs. It's not taken on some anonymous street corner. It's taken in front of this club. The patrons of that club can see and perceive it as one thing. The court ignored it. The trial court, and then, no disrespect to the majority, they did as well. They backed into this analysis of owned and controlled by through their own self-contained definition of the word run. They said, we never saw a reference to the ownership of the club and the factual allegations, therefore they couldn't have run it, and then they referred to...
Has there ever been a case that you can point to where employees of entities not of the club, not of the entity itself?
There is the Baker case that we referred to where the police department officers fall under that same reference that the dissent made reference to. It's worthy enough of a strong case to support, again, if it was in any other criteria that we're applying this case, if it was one that the light most favorable to the non-mover, if it was any other scenario, then I would agree. Then this case is not that strong. But because we never made it past go, all we had to do is presume the facts stated in either the complaint or in a supplemental affidavit can support that an allegation sufficient to satisfy the element for a cause of action for defamation exists. Analysis over. The majority
Thank you, Mr. Whitehorn. You have your 3 minutes. Let's hear what Mr. Brown has to say.
Thank you, Your Honor. May it please the Court. The fundamental problem with the plaintiff's argument and with the dissent's position in the appellate division is that it confuses pleading a fact with pleading a question of law. And the question whether a particular challenge statement, like the statement federal authorities say this club is run by the mafia, in the context of the noon report here, the question what that statement is reasonably capable of meaning is quintessentially a question of law, and although the plaintiff is entitled to plead what they or it believes is the correct conclusion, that's not a fact to be pled, which this court or any judge is required to credit.
You're saying of and concerning is a matter of law?
The reasonable meaning of the statement in evaluating this motion, which raised the point that this statement is not reasonably understood in the first instance as of and concerning these plaintiffs, that presents a question of law for the court. The cases are clear on that. The court then looks to the statement.
Why isn't it a reasonable meaning? I mean, run by the mafia, that run, isn't that a colloquialism as opposed to owned, controlled, or some other managed, something that's more specific? But run, doesn't that include potentially these plaintiffs? And couldn't patrons view this to refer to them?
No, Your Honor, for two reasons, and they're the reasons laid out quite clearly by Justice Coyne in the IAS part, and then also by the majority in the appellate division. The cases from this court are clear that the court is required to consider the words actually used in the context in which they appeared, which is a noon report focusing, it's a brief report focusing on an ongoing government bust of an organized crime ring. We're told that organized crime figures were bringing women illegally into the United States and forcing them onto clubs.
Suppose instead it said it run by, it says the club not only is run by it, but is permeated with mafia figures in its employment.
That would be a very different situation, Your Honor. You then turn to whether these plaintiffs can satisfy the small group libel hurdle, and I'll turn to that in a moment.
Before you do, but when I heard the statement, I thought, oh, that means that the mafia is in there running this club. That's how I interpreted it. So this is maybe an unfair question, but is that unreasonable?
With all respect, Your Honor, yes, because you have to look at the common meaning of the phrase.
What if 4 of us on this court think it's reasonable?
If 4 of you on the court think that's reasonable, then I go to my fallback argument, Your Honor, which is the small group libel bar. But let me just spend one moment on why that wouldn't be reasonable. And it's one of the reasons we cite to the court the criminal cases in which judges have used the phrase controlled by or run by the mob in...
well, controlled by, run by, might be 2 different things.
The point being, Your Honor, that there is a common understanding, perhaps not universal, but that's not the question. There is a common understanding what the phrase run by the mafia means, particularly...
And how do we know about that common understanding? How do we know that the court is, the appellate division is right as a matter of law, especially when they split 3-2?
Your Honor, you look at the context of the report and evaluate it in that context. And I may not be able to persuade you that that is the reasonable reading.
You're saying the context is that the people involved are external to the club, and that's why you can't read run by the mafia as including people who are somehow employed in a particular way already in the
Exactly, Your Honor. The whole context of the Noon report is about outside extortion and forcing of conduct on clubs. It is not reasonably understood as referring to the staff. We have here the hostess, who apparently seats people, according to the affidavit, seats people, makes sure they're comfortable, the fellow responsible for making sure the liquor supplies get in, and the fellow responsible for identifying and scheduling the dancers. It's the staff who do day-to-day
So is that
operations.
external group a group of Russians? Is that what the report means?
According to both the report and the indictment, there
So
are...
why not say the Russian mafia to clarify that?
It refers to mafia figures from both Russia and the United States, Your Honor. Exactly.
Okay, so why couldn't someone think they're the American-based mafia members
I think the court is
running
entitled...
the club?
I think that the court is entitled to take judicial notice that made members of the mob do not generally work as hostesses or stockmen in commercial operations.
But that's not what they're arguing, right? They're not arguing about the barmaid or the bar person.
That's who these three plaintiffs allege themselves to be in the affidavit by Dominique O'Neill, which is part of the record. None of that is in the complaint. It's all in the affidavit. But Your Honor...
You know, when you talk about, though, looking at it in the context of the report, it starts to sound to me like it's a factual question, not a legal question.
The cases are legion, Your Honor, that this is an initial determination to be made by the court. And the key point here is exclusively by looking at the language of the report. And that's important not only for this issue, which I may not be able to persuade you on, but the second issue, which is that if you are prepared to find that reasonable people would understand this statement, Cheetah's is run by the mafia, in the context of this report, could reasonably refer to the staff operating Cheetah, those plaintiffs still need, in order to proceed with their claim, to satisfy the bar on group libel claims. That is, when a statement doesn't refer to someone expressly, but rather to a group, plaintiffs have to satisfy the requirements for pleading that kind of claim. And as the cases that both parties rely on for that make clear, you evaluate that as a question of law, as a threshold matter, by looking to the statement, the challenged, allegedly defamatory statement, for whether it defines the group, a group, that plaintiffs claim to belong to, in the words of the de Blasio case, objectively and unambiguously, or in the words of the Brady case, which is perhaps the leading case, it's out of the Second Department and is the most frequently quoted case on this point, you isolate, you define the group by the terms of the alleged defamatory comment itself, and you look to see whether the group is explicitly defined, whether it's a highly organized, quote-unquote, group that exists, has a structure independent of the allegedly defamatory comment, and you look, the court said in Brady, to see whether the composition of the group is definite and fixed from the comment itself. And that's where both the dissent below and plaintiffs get off track. You do not look to the allegations of the complaint for that in the first instance. You look to the comment itself. And here, the ultimate problem for plaintiffs is that run by the mafia, with reference to the Cheetah Club, is simply too indefinite in terms of what the parameters of that group are. There's no objective way for the court to determine how many members that group has or who they were with any certainty or sufficient certainty
Are
at
any
any
of those
point in time.
factual questions that cannot be decided on this motion?
No, Your Honor, it's the language itself that's too ambiguous. And for example, in the Brady case, which I believe counsel referred to involving certain police officers at a police department, the editorial expressly criticized those people who had been police officers on a certain date and who were not indicted, and accused them all of having guilty knowledge. And the Second Department, Brady, painstakingly went through application of the small group libel exception to the rule against group libel and said, this is a situation where it is absolutely clear what the parameters of the group were. It's very specifically stated on the face of the allegedly defamatory editorial. A fact finder is capable of determining conclusively who is within that group. And therefore, the one officer who brought a libel claim saying, alleging, I was a police officer on this date and I was not indicted, so I'm a member of that clearly defined group, could proceed. Quite simply, the phrase run by the mafia with reference to a business establishment doesn't define which group we mean. As Your Honor's question, I believe it was Your Honor's question about the owner of the club signifies, what of the chef? This is a restaurant. We know from the record that they serve elaborate sushi dishes and steaks. Is the chef not part of the group that runs the organization? The court can take judicial notice that clubs of this nature have security departments. Where are they in reference to defining the group? The difficulty...
Well, maybe that's a reasonable understanding, but that's not suing.
But the reasonable understanding must derive from the definition of the group found within the defamatory comment itself. It would require overruling literally decades of precedent to find otherwise. This goes all the way back to this court's 1936, and I see my time is up.
Please finish your thought, yeah.
I just want to refer the court to Gross versus Cantor, which is the radio editor's case. In that case, the court allowed the claim to proceed, in part because the allegedly defamatory statement was directed specifically at people holding a job title, radio editor, of which there were apparently only 12 in New York City at that time, one of whom had been expressly excluded by name from the 11 who were allegedly defamed. The group was definable by the words of the statement itself, and that is my final point. I'd ask the court to make this ruling based on the words of the statement in the Noon report, not the allegations of the complaint. Thank you.
Thank you, Mr. Brown. Mr. Whitehorn?
Thank you, Your Honors. I will take a minute, reply. The majority did say the portions that we acknowledge the decision is clear on, and they made those on the matter known as Tracy, and the other matter they referred to was Springer. In Tracy, there was no dismissal. It was full-blown trial. Full opportunity from all the parties to present hard evidence, witnesses, testimony, affidavits, photos. We didn't have that. Tracy didn't apply to us. Springer referred specifically to a fictional piece, not a true piece. The perceiver in a fictional piece was analyzed under Springer could be different than the analysis made by the viewer in real life. So transmitting, comparing a fictional piece to a real person is different than a video taken, statements made that include...
Well, the point of Springer was that of and concerning is a matter of law. Isn't that what it was cited for?
True. And both of those that reference Tracy and Springer touch on this matter of law component where the majority made a mistake. The factual references made by those matters that the majority relied on, they don't apply to us. We don't have those same facts. We have something dramatically different.
You're saying there are circumstances under which of and concerning may be a question of fact?
Yes, there are in Springer, where the perceiver, they step in the shoes of the perceiver and they say, it's not worth the factual analysis of what the extrinsic evidence will reveal. It's so clear that a fictional piece, in order for it to be interpreted and applied against an individual, is something that the trier of fact can determine as a matter of law. So that was the Springer basis. But in our case, we have a sentence. I don't have a book. I don't have an entire, I don't have the list of items that the court can refer to and transpose to real life. We have run by, if I might just finish this one point, run by is stated in there, managed by is stated in there, run by the mafia. The word mafia elicits such a broad perspective of factual inclusion of every single person.
You don't want to miss Judge Stein's question. Hold on.
I would really like you to address the small group
I will.
libel test, and you've
Under
got
the
very
small
little
group-
time left.
If the details of our case were broader, then I believe the application defining the group under the small group libel, it's available. Under this case, we have to presume the facts stated in both the affidavit submitted during the trial court and the
But if you
complaint.
look at this, your opposing counsel wants us to look at the statement itself. And if we look at the statement itself, can we determine who's in the group of run by?
Say that because the material that the court is left to work with, to apply to this test, because it is so small, the words are, I could reduce them to, I think it's a total of 30 words that we're referring to. In the use of those words, you're required to take such a small scope of words and apply it to, could it have been objectively or unambiguously referring to the employees? The video alone shows the backdrop, people being arrested. There's a pan and scan on people that are actually coming out of the club in handcuffs. There's no distinction. They don't wear a shirt that says, "Hi, I'm the owner." There are people that are being arrested. There's references to FBI. The facts stated in the report compared to the video that plays behind it, it clearly includes objective ability for the court and unambiguously referring to these people. And the terms included in the statements, does it define the group? Is it a definite and fixed group? And again, you're asking, the court is, I'm asking you to review the trial, the appellate division's interpretation of the words run by, managed by, and then once you throw in the word mafia with this analysis to this organized syndicate of crime, there was reference made to the cook. Anyone that works there, the implication could be that somehow or another they're related to the mafia, or else they wouldn't have got a job. So,
Thank you, Mr. Whitehorn. We'll take a look at it.